recording now. Okay, so welcome everybody to the March meeting of the PRC. We have a couple of guests today, which Howard will introduce in relatively short order, so welcome. We have a couple of regrets, Andrea and Kyle, and again we have the standing regret from Matthew, although he indicates he may be able to join us during the meeting, so we'll see if that happens. And Rob's going to join us right now, so I'll let him get in. There we go. Rob's here. All right, guys. So you've got the agenda and the minutes for today, minutes of last month. So can I have a mover to accept the agenda as circulated? Howard, second. John, all approval. Thank you. All right, and we have the minutes from the February the 14th meeting. So can I have a motion to accept those minutes? John, seconder. Stefan, all in favor? Thanks very much, carried. Okay, news and announcements. Lots of news. We'll end up covering most of it, I think, as a function of the briefs we're looking at and the bills that have been put forward in the last month or so. I have a note here regarding Peter. I think he's still working on a draft brief regarding the replacement of the RCMP in Alberta with an Alberta provincial police force. Peter, anything on that yet?
Yeah, that's still a work in progress. I had actually intended on doing it for today, but best laid plans of mice and men. One new thing that is interesting, though, on the same context, is that the City of Grande Prairie, Alberta, in a vote of 8-1 by City Council, has replaced or will replace the RCMP with their own municipal police force. Interesting. I happen to know a lot of people up there, and interestingly, it will be modeled on a tiered policing model. So there'll be a strong emphasis not just on sworn police officers under the Police Act. There'll also be a strong emphasis on using members that are covered under the Peace Officer Act, which is unique to Alberta. So they'll be using community peace officers in conjunction with police officers to provide that tiered policing, which will actually be quite an interesting experiment. The provincial government is giving them, I think it was $9 million. John, you may be closer on that number than I am, but I believe it was $9 million that the provincial government is funding them for the transition. Yeah,
Thanks. I was just going to ask you that. I mean, what's the population of Grande Prairie?
100 and something thousand. It's a very it has the highest under the what's it called, crime severity index is the highest in Canada, which is really interesting. I actually did a major study on replacing the police up there about 7 years ago, and at that time things haven't really changed. Part of the problem is that the cohort of 15 to 25-year-olds, which is one of the criminogenic factors, that when you have a high population of single males in that group, it tends to correlate to crime. Well, that's just the case. It's part of the oil industry. There's people in and out. The sort of buy-in for making this a safe city is removed because of the transient population who are just going in there to make, and it's like filthy rich up there. I remember one day walking around, and just in a matter of 5 minutes, I think I counted about $4 or $5 million of trucks, the Alberta truck, and that people had, the F-350s and all that stuff. Those things are worth, $150,000, $200,000 fully loaded, and like there's just thousands of them all over the place. So money to burn, very high drug use up there. So it's going to be a very interesting place to see. Probably the telling metric will be if the crime severity index comes down. That would be probably something, because they've got a good pattern of our trend line that's been established over the years. So it'll be interesting to see what happens after, say, 2 or 3 or 5 years of that experiment.
Yeah. The reason I was asking is my personal experience. I was a police commissioner 100 years ago in a mid-sized force, and it tends to take up a chunk of a municipality's budget when you go with a municipal force. it's just unbelievable how much it takes to run one. The $9 million that's being given to the province won't last long at all with a force, for that size.
Yeah, it wasn't so much to fund it; it was to the transition over.
Okay.
It was where that money was being allocated for. The other thing too is that under the what is it? The municipal policing grant, not grant, but the what's it called, MMPI, the municipal policing contract between Canada and Grand Prairie because the RCMP are the municipal force there technically right now. As a result, there's not a huge payback from them, unlike rural areas, which are still getting a 30% discount for the time being anyways. And that's one of the big arguments. So really, Grand Prairie is funding their own stuff to begin with anyways.
All right, thanks, Peter. Okay, so we'll keep the brief on the agenda to come. Next is Howard. Howard is going to introduce to us the two students he's brought with us. So Howard, the floor is yours.
Thank you. Thank you, Miles. Just before I do that, and I don't want to keep the students waiting too long, just in the context of news, I wanted to point out something that we had covered in the newsletter, but doesn't seem to have hit the press in a big way with other things going on, and that is the revival of the Law Commission of Canada. So in a Toronto Star article dated February 22nd, and that is in one of the newsletters, not this one, not the one before, but the one before that. There's an announcement from the federal government that they've appointed a full-time president and two part-time commissioners. So the Law Commission of Canada, which has not really been in existence since the Harper era demise of it, is being revived. A little disappointing to me that neither the president nor the two part-time commissioners that have been named have much of a background in criminal law. But it is hopeful that the Law Commission of Canada is now sort of in business. I think it's fledgling, waiting to sort of get off the ground, but we'll have to wait to see what happens. But if you need the link to that, just let me know and I can share it with you. But it was in the newsletter 3 issues ago. Okay, so anyway, without further ado, let me turn to our delightful pro bono student Canada Law students. I have to say that and of course I should say their names, which we haven't yet this morning. Becky McCrae and Taylor Sullivan, two of the brightest and most thoughtful law students I have worked with, and I think that's saying something because we've had some pretty awesome pro bono student Canada Law students in the past. But these two young people are not just law students, they're so much more. And let me tell you just a little bit about them. I'll start with Taylor. Taylor has done a BA in International Studies at the U of O and is currently doing a joint law degree and MA in International Studies. Until this month, she has been working with the War Crimes Unit in the Department of Justice, a very difficult assignment and very wearing when we look around the world these days. Taylor has told me that recently that she's going to be taking up a summer job in Vancouver with a defense counsel. So I'm glad to see she's kind of broadening, from the prosecution war crimes unit to defense counsel. I think is a good way to kind of round the background. But I'm going to shortly call on both Taylor and Becky to tell you a little bit more about themselves. Taylor has an interest, among other things, in intimate partner violence, and so she'll speak to us about what she's doing there. So let me turn to Becky. In addition to working on her law degree, Becky has both a BA and an MA in criminology from Guelph, so she's certainly well versed in the subject matter and the areas of our conversations. In addition to that, Becky has worked with what I regard as probably the best law firm in Ottawa, if not in the whole province, Edelson Ford, and is now working with Nicholas Lust, another well-known defense counsel in Ottawa. Becky is the co-author of a very thoughtful and evidence-based paper on bail reform, which was featured in our newsletter, not featured, but added It appeared in our newsletter. We don't feature any particular article. We just list them by date. But the author that she co-authored on bail reform, which is a very thoughtful evidence-based piece, is there, and you should have a look at that. Becky's also involved with a number of nonprofit criminal justice-based organizations, and speaking as a father, she's involved in a business with her father who is ailing, and she's taking care of him. And as a father, I have a special place in my heart for daughters who take care of their ailing fathers. But anyway, two remarkable individuals. Now, I'm going to turn to them and ask them to tell you a little bit more about themselves and what they're working on. Taylor, do you want to go first?
Yeah, sure, no problem. Everyone can hear me okay? Cool. So with the CCJA and Pro Bono Students Canada, I'm working on a parliamentary brief in response to MP Randall Garrison's Private Members Bill, Bill C-202, which seeks to add coercive and controlling conduct into the criminal code. So specifically, I'm looking at operational policing and prosecutorial challenges with just adding the offense into the criminal code without additional supports or mechanisms in place, both provincially and federally. Operational being in summary, a lack of a clear definition of what coercive and controlling conduct entails, both across jurisdictions as well as just in general as a criminal offense, leaving the door open to significant judicial discretion, which could be rather problematic for this type of intimate partner violence. Policing challenges focus predominantly on a lack of awareness or a lack of education surrounding intimate partner violence writ large amongst police forces and gender-based violence writ large amongst police forces, as well as tying into the operational considerations of a lack of a clear definition, making implementation quite difficult for police services. And then also with a brief mention of mandatory charging regimes and how that will be related to criminalizing coercive and controlling conduct within Ontario. And then prosecutorial challenges. I want to speak most predominantly on the potential for re-victimization on the stand with respect to the burden of proof for proving coercive and controlling conduct. Often that could involve accessing victims' therapeutic records. And then, as we all know, in our adversarial system, a victim's voice is seldom heard in its totality. And in gender-based or intimate partner violence crimes in particular, that can be especially trauma-inducing for survivors and victims. In that analysis section as well, I will also have a separate and distinct section for victim considerations, just identifying partially what I've said in the prosecutorial section, but then also diving further into the hybrid nature of the offense and how the cap at a 5-year sentence or the potential for only summary conviction, as well as the lengthy criminal process kind of throughout from charging all the way to potential prosecution, conviction, sentencing, and then post-sentence release, how if a victim does not receive adequate supports and social services, we could be opening them up or leaving them vulnerable to recidivism or reoffending after the fact. So that's kind of the crux of my analysis. And then what I'm most proud of and what Howard has been very supportive and helpful in helping me kind of sort out are the recommendation sections. And I'm very excited to be looking at types of extrajudicial measures or extrajudicial sanctions, kind of reminiscent of what we see in the Youth Criminal Justice Act and certain drug offenses, to explore the opportunity of, instead of enforcing imprisonment or going through the traditional avenue of the criminal justice system through a trial, exploring instead consultation between the victim and the offender to come to a mutual agreement for a response or a remedy to the situation. I'm excited about that because I think it's an opportunity to really change the dynamic of intimate partner violence offenses and gender-based crime, to put some power back into the hands of victims in general. And it's also a great tool, or could be a really interesting tool for alternative means of justice or alternative dispute resolution tactics that might be more suitable for intimate partner violence rather than the traditional criminal justice realm. But that's a lot of information, but in a nutshell is what I'm working on. And Howard's been really excellent in helping me navigate the process of parliamentary bills and how they go forward, the nature of private members' bills, and then also just the criminal justice system and getting creative with potential recommendations. So it's been a really exciting project so far, and I'm happy to be working on it and very grateful for the opportunity.
So we will have a brief for the PRC to consider at some point in the future. And from what you heard, Taylor has a tremendous perspective, taking into consideration with great sensitivity the needs of victims in this all too prevalent kind of offense, but also a very critical eye on expanding the criminalization in this area into behavior that is difficult to objectively ascertain. But anyway, stay tuned. More is coming up. I think you're going to really like this balanced and reasoned approach with some interesting additional ideas that aren't traditional criminal justice approaches. Now, let me turn to Becky. Becky has a great interest and background in bail issues. And of course, we have seen at our board meeting yesterday, but also more generally, the focus on this upcoming and the announcement on Friday that the FPT ministers responsible for justice have agreed on a broad framework. But I want to call on Becky. Becky's working on a particular slice of the bail issue that adds two very important elements that are not often discussed. So Becky, please take the floor.
Thank you, Howard. First off, thank you for letting us be here today. It's such a privilege to meet everyone. And it's been an absolute pleasure to work on this project. As Howard mentioned, I started off my interest in my undergrad degree with criminology. I really like studying bail principles and how they're applied, the remand population, and then just following it throughout my education and just seeing the trends that aren't changing. So my current project that we were working on is to what extent do GLADU principles apply at bail? So me and Howard were discussing looking at represented and unrepresented individuals in the justice system that identify as Indigenous, and trying to get the data to first explore whether or not GLADU principles are being applied at bail. And then the second step is if they are applied at bail, to what extent are they being applied? And then I want to get into a full depth analysis of looking at some case law that's been applying GLADU principles or just mentioning them briefly and seeing the role that they're playing in the current courts during the remand. And then I want to look at some of the general recommendations that secondary sources have suggested, particularly in the news, as we all are quite aware of. Bail is a really hot topic right now. They've been talking about reforms for quite a while now. And then with the ministers of justice meeting, they did mention that they are in agreement of some of the things, but they're not giving us a full picture of exactly what. They did mention they are looking at some reverse owns, that it is on the table, but they're not quite coming out with it. So I did want to look at exactly how this might impact Indigenous people and trying to push GLADU principles to be applied. Currently, I believe there's only a few provinces that have been actively using it. So I've just been reading through case law and understanding how they're being used, and which ways we can actually use them to benefit the program. Particularly, I have an interest in the remand population, the issues that are going on there, overpopulation, deaths in custody. So I'm looking at trying to understand how first the system's working and what's not working. And then I want to go through some recommendations to hopefully give some guidance in that topic, particularly with Indigenous people in remand population, my apologies. And then hopefully put forward a paper and then just kind of outline what we should be looking at and really focusing on evidence-based policies. I know the government's really quick to mention evidence-based policies, but what the proposals I've been seeing right now are not focusing on some of the issues. So just kind of highlighting those issues and hoping that maybe we can see some changes in the remand population in terms of bail and bail release.
Thanks, Becky. Becky's been looking as well into data sources to try and understand the real numbers in terms of part of the evidence about remand population in Ontario. And so she and I've been surveilling some data sources, and it's frustrating as always. Stats Canada has a bit on remand populations, but of course Stats Canada looks more at the federal situation, whereas remand populations are provincial. And the intersectionality or the overlap of remand, unrepresented accused, Indigenous background, there's not a lot that shines a light on that situation. There should be. But Becky and I've been trying to explore data sources on that, so you may see some of that. Becky's work will take the form of a paper rather than a brief, which we hope to bring to the PRC table at some point in the future. One of my rules as the supervisor of my two students is that their health comes first and then their school comes second, and CCJA is there somewhere, but they have to take care of themselves, and that's critical, particularly today. But I think you will see this year we have two exceptional young lawyers in the making working with us. So I'm thankful for for just the pleasure of being able to chat with them and work together on something. So back to you, Miles.
Thanks, Howard, and thank you, Becky. Thank you, Taylor. We appreciate that. Very interesting. Good luck. I'm sure you're going to produce something that's very worthwhile, and we look forward to receiving it. So again, thank you. Okay, with business arising, we're going to deal with the parliamentary committees. So the first one, it's back to Howard for Justice and Human Rights in the Commons.
Thanks, Miles. As some of you will recall, I wasn't present for the February meeting, so my last report on this was in January. And in January, the Justice Committee had not held any hearings because they were on their Christmas recess. So since the new year, let me say, there have been 9 meetings starting on January the 30th and flowing through until March the 8th. I'm not going to go through each one of those meetings with you, but I'm going to focus primarily on 3 areas. But I wanted to highlight that at the January 30th meeting of the committee, which dealt with what they call business matters, the committee approved, among other things, that the committee undertake a comprehensive study regarding Canada's bail system, that a report be tabled in the House of Commons, and that the committee make recommendations to, and I'm quoting here, answer the call for immediate action from all 13 premiers of the provinces and territories who, in their letter to the Prime Minister, dated blah, 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 unanimously urged the strengthening of Canada's bail system, particularly where gun violence is connected, to better protect the public and Canada's heroic first responders. There's more content there. I won't read it all. They promised to do 6 meetings, and they're prioritizing this study, and I'll come back to that in a couple of minutes below. With respect to the usual committee work, which is reviewing bills that are in the process of passing, the committee hasn't done any of that kind of work since the Christmas break. They've taken a very quick look at C39, and let me go to that quickly. They reviewed C39 not in the context of a bill before them as part of the usual process, but in the context of a bill that was moving it at a meteor's pace through Parliament. C39, you may know, is the one dealing with medical assistance in dying. And it was introduced by the Minister of Justice subsequent to his promise to delay the inclusion in the MAID regime, MAID, of course, being the acronym for medical assistance in dying, although MAID seems to me to be just the wrong kind of image in all sorts of ways. But anyway, the Minister of Justice had promised to delay the addition to the MAID regime of people applying for medically assisted death where the sole underlying medical condition is mental illness. So again, you will have seen a lot of this in the media. There's been a lot of controversy about it. Initially, the government bill didn't include mental illness. The Senate pressed upon them to include it. They included it, but with a year's delay. The government is now seeking to delay that by another year. So the bill has already, I believe it's already passed. Miles, I think you have it on your agenda down below, is passed. The committee looked at it only pursuant to a unanimous motion from the floor of the House of Commons, where the committee be asked to look at it in one day. So they had various witnesses, including the Minister of Justice and health officials, Health Canada officials, where they presented and questions were answered, but the committee didn't take any vote on it. So there's no usual report by the committee. It wasn't a committee study of the bill as we have come to understand it. But that's C-39 has now passed, so we have to wait another year to see what the details of the government's approach to the inclusion of mental illness in their MAID regime. And it's a difficult, very difficult issue. For those who are more interested, there's a senator, I'm blocking on his name, who led the inclusion efforts for mental illness, and he was a professor of psychiatry. Stan, I'm just blocking on it, but he does a very intelligent kind of defense of the inclusion of mental illness, and he distinguishes between suicide and mental assistance in dying, and that takes a little bit of a thought process to understand what's the difference. But he said the medical assistance in dying regime was never intended to catch people who were impulsively on the verge of suicide. Anyway, it's an interesting thing that I don't know a lot about. It's been delayed for another year, so stay tuned on that. Let me go to another item quickly. The committee is undertaking a study of extradition law reform. Pursuant to a motion adopted by the committee itself in September of 2022, I think you'll recall, maybe this is the time when there's a lot in the press about Professor Diab, a sociology professor at University of Ottawa, but also about Meng Young and the proceedings in Canada to extradite her under a request from the United States, and the response from China with the imprisonment of the two Michaels. Anyway, I think the public context pushed the committee to undertake what they're calling a comprehensive study of extradition law reform, and particularly the 1999 Extradition Act, and they're proposing that they provide recommendations to the committee on how to overhaul the current system so that civil liberties of all Canadians and permanent residents of Canada are respected in an extradition process. They talked about holding 3 meetings, then tabling a report, and calling on the government for a comprehensive response. And that was the motion they passed in last September. The committee has had 4 days of hearings, February 1, 6, 8, and 13, 14 witnesses, 5 briefs, certainly including Justice Canada officials. One of the witnesses is Donald Bain, who was Hassan Diab's lawyer. Donald Bain is a criminal practitioner. He's been a defense counsel for 51 years. He's very well known here. He represented Mike Duffy, I believe, as well. At any rate, this is what he said to the committee. He said, members of the committee, as a guy who's been 51 years in the criminal justice system in this country, my perspective is that this is the most unfair process and law that I've ever encountered in that half century of practice. So in addition to Donald Bain, they've heard from Alex Nev, who is now a senior fellow of the Graduate School of Public and International Affairs at U of O. Formerly, I think the Director General was the title of Amnesty International. They've heard from the International Civil Liberties Monitoring Group, the Work Seek organization, an interesting group called Women Who Choose to Live. They're women who they describe themselves as working with women who are criminalized and punished. I'm sorry for my slip of the tongue. Women who are criminalized and punished for trying to survive male violence. So at any rate, on February 13th, the committee gave drafting instructions to their analysts. We don't know what that will look like, but stay tuned. When that report's available, I will share it with you and we can have some conversation. And I have a tendency, as you all know, of speaking too much, so I'm going to try and bring my report to a close here. But probably the most highest profile thing that the committee is doing is their study of bail reform, and I read to you their terms of reference. I worry a little bit, given that their study is predicated upon the Premier's letter, and they talk about heroic first responders. They don't talk particularly about the remand populations and the death of people in remand custody and other kinds of things. They've heard from the Minister of Justice and Justice Canada officials. They've heard from 4 police forces. In addition, they've heard from a couple of professors, one being Nicole Myers, an associate professor at Queen's University. If you get a chance to look, Dr. Myers is a professor in the Department of Sociology there, so criminology is her bent. But there's a brief on the website from the committee that is absolutely astounding. You ought to read it. She is a true expert in this area. She has evidence-based recommendations. She recommends changes to the bail system, and in some cases, a whole bail review. But her testimony is not representative of most of the testimony that's been before the committee so far. They have had Emily Coyle from E-Fry, Jennifer Dunn from London Abused Women's Centre, 2 professors who spoke with great eloquence. At any rate, the committee's hearings are ongoing. This is assuming a real public profile with the Minister of Justice's commitment following the minister's meeting with federal, provincial, territorial ministers on justice. We'll have to see what is introduced. There's a real heat below this initiative, although I'm not sure how much light. But if you get a chance to look at Professor Myers' brief, please do so. It's a wonderful piece of criminal justice, criminological policy work. So anyway, I think I'll stop there, Miles, but I'm happy to respond to any questions.
Excellent. Thanks, Howard. Any questions or comments for Howard? All right. Thank you. All right. Let's move on to the Commons, Public Safety and National Security. So, Rob, you're up.
Thanks, Miles. This one will be brief because there were 3 meetings held since our last meeting, and they were all on Bill C-21. The effects of the withdrawn amendments, G4 and G46. So basically, they're kind of going around. They've been talking again, not necessarily to the same folks, but they seem to have last year talked to a wide variety of folks on this bill, and now they're going back and talking to representatives from similar areas, such as Indigenous groups, academics, those in the hunting and fishing industry, fishing suppliers, those in the hunting, fishing guide industry, women's groups, groups who sort of formed following a major victimization of some kind, or related to guns. So a variety of folks, but there seems to be still a lot of questions around the definitions, what's going to be caught up in these in the list of guns that are weapons, firearms that will be affected by the bill if passed. So on February 17th, they spoke to an academic, a hunting supplier, and a hunting and fishing fellow from the guide industry, and related to the definitions in the list and the way to categorize guns. The academic actually suggested a new way to categorize guns that will be different from how it's done now. I read about it, but I won't get into it for the purpose of this meeting. It was interesting. So again, questions about what's on the list, what's going to be captured, concerns that the Americans may not come as often up to the north to hunt and fish and spend their money. There's a big industry there. Indigenous groups are concerned about what they'll be able to use, going forward. So, and then March 7th and 10th, there was no evidence available for those, but the committee spoke to, similar folks. So I suspect there were similar concerns, the same concerns they've been all along. And that's about all I can say. So I'll stop there. 3 meetings on Bill C-21, same old concerns. And that's where we're at with that one.
Thanks, Rob. Any questions or comments for Rob? Okay, thank you. Next, we have the Senate Legal and Constitutional Affairs. This is Brendan's committee. I didn't receive any regrets from Brendan, so I didn't realize he was not going to be here. So we'll ask him to bring us up to speed when he attends, I presume, next meeting. for what's happened in the last month or so. Lastly, the Senate Human Rights Committee, it met once. It met on March the 6th. It was, again, it's further examining all issues that arise regarding human rights, and most particularly, its mandate deals with Islamophobia. It had a meeting on the 6th. So in attendance was Kareem El-Abad, who's an imam, Rabia Kader, who is the Chief Executive Officer of the Federation of Muslim Women as an individual. She was there in her own capacity. Pierre-Paul Nero, who is the counsel for the Quebec Press, and Michael Taylor, who's also an imam. The lessons taken away from the discussion is that Islamophobia, including online and offline violence to Muslims in Canada, is on the rise. One of the panelists described his experience living in France in 2008 with his family. His wife was adamant that they had to move out of Europe due to the intense Islamophobia found there. They moved to Canada, which they saw as a country free from the rabid discrimination that they were used to. Over the time, however, they do not see Canada as being any better than where they left. Violence is particularly highlighted in the province of Quebec. The remedies discussed involve better education for the Canadian public and what it means to be a Muslim in general, and in Canada specifically. It was also proposed that appointing or electing Muslims to decision-making positions would be an appropriate step to take, and further meetings on Islamophobia will continue. So that's it in a nutshell. There was only the one meeting for this committee. Any questions or comments? Okay, thank you. Great, folks. So let's move on then to further business arising. The next item is item 5-B, Criminal Cases Review Commission report. So as you would likely know, since our last meeting, there's been the introduction of Bill C-40, which is to establish a Canadian Miscarriage of Justice Commission. I'll have more to say on that when we get to Bill C-40 in that bill portion of the meeting. So let's put that over till then. On the item sub D, the draft brief that's being prepared by Brendan on Bill C-289, that's a waiting brief. And then the next item is Peter. This is regarding the invitation for the consultation on facial recognition guidance, and the Office of the Privacy Commissioner of Canada published a draft, and Peter was going to give us a few words on that.
Thanks, Miles. And just to short, do it up fast. Lynn and I haven't been able to get together. I don't know. We're going to try again one more time to get something further on that. What I do want to talk about briefly here is I did attend I visually attended the Canadian Civil Liberty Association webinar on March the 8th. There were 4 presenters and a moderator for that day. The primary theme focused on facial recognition technology. There is general agreement that there's a lack of legislation to adequately address the issue and risks to privacy. Facial recognition is not controlled. There's no legal framework, according to the panelists. Rather, it's a patchwork of legislation which is not sufficient for governance. The Clearview example was used oftentimes throughout the discussion to highlight this. The Clearview example was something that we remember all the privacy commissioners in Canada got, well, not all of them, but the federal privacy commissioner and some of the provincial got together to look at Clearview AI. Sorry here. There was also added to this issue was that facial recognition technology it appears to be inaccurate, especially when it involves Black or Indigenous persons. And police use of facial recognition was frequently referenced in a very negative manner. It was also interesting, there was a comment that in China, the use of facial recognition technology is ubiquitous and is actually very effective. Interestingly enough, they've got it right for looking at people of Asian origin, and we seem to not have it right, which is interesting. I just find that from a technological fix standpoint, it's just an interesting observation. The panel argued that the technology exists to end public anonymity And the only thing preventing this is law and policy that we currently have, as inadequate as it may be. Facial recognition in the US has minimal data collection privacy laws, and UK is used in a vast array of contexts, and according to the presenter from the UK, requires large-scale systemic change. Facial recognition is used in both democratic and autocratic states, and the presenter from Israel provided an example of Blue Wolf technology, or Blue Wolf system, which is an application used to spy on the Palestinians, and I'm quoting here, in the occupied West Bank. This is a smartphone technology that captures images of Palestinians in the occupied West Bank and then matches them with a database run by the Israeli military and intelligence. And people are, if I remember correctly, either green, orange, or red. Green meaning that when they're matched up, yeah, they're free to come and go. They're no threat. Orange is we need more information, and red, detain them and bring them in for interrogation. Sort of an interesting concept there. One presenter also believed that the term facial recognition systems was more appropriate than technology to be used, generally speaking, to call it systems rather than technology, because the problem is not with the technology per se. Technology, as any other machine, can be fixed or changed, but it's with the use of the systems of that technology within systems. Just a subtle point. They asked about where to engage the public to see that facial recognition is a threat. There is general agreement that there is a need for a large-scale systemic change. It was also noted that our striving to cease facial recognition in a democratic society can only occur in a democratic society. In other words, there's nobody arguing about it in China, as if, for example, because they're put down for doing it. It's only because we have the luxury, I guess that's the term, of being a democracy that we can actually speak about this. So that's something to always remember. Banning the technology is not realistic, and some of the examples was the FR technology used for passport control. It is highly effective and very, very accurate in that usage. Technologies have use, but putting on the brakes will be problematic. And 3 prescriptions were offered. One was to try to stop the pattern of secrecy without transparency. Second was proportionality. In other words, address the more severe effects of facial recognition technology. And the third was oversight. Traditional systems of oversight are not sufficient for the new technologies associated with facial recognition. And mention was made of the new Artificial Intelligence Act, which is before Canadian Parliament. I've been trying to get in touch with the Civil Liberties Association to see if their webinar is actually going to be available for rebroadcast. And I can tell you that they are very good at asking for money. When you try and get in touch with them, it all goes to the answering machine and how much do you want to donate? But I haven't been able to get an answer back on the concrete issue of is your webinar available? So that's just my report on that one. Thank you.
Yeah, thanks, Peter. That was terrific. Any questions or comments for Peter? And so you and Lynn are still working on a brief to come back to us. Is that the idea?
Yeah, we are. We just haven't been able to get together. As much my fault as anybody's. Probably more my fault than Lynn's. I just we had some unfinished business from our last time we got together, and what we put together there that needs to be fleshed out a bit more. And that's I would like to get that finished off. So I will undertake to get in touch with Lynn, who I was seeing nodding her head, saying yes. I'll be waiting for you.
Okay, thanks, Peter. Thanks, Lynn. Okay, so we'll keep that on the agenda. So thank you very much. All right, the next active item.
Miles?
Yes.
Sorry, Miles, just 2 little things quickly. I just think people would want to know. One of which is that Brennan had sent an email both to you and to me asking for the link for the meeting. And so Brendan Johnson, he sent the email about 12:03, and I just saw it about 10 minutes ago and sent the link on to him. But by now he may have missed the opportunity. So for whatever reason, he didn't get the link, and that's why he's not with us. Secondly, just quickly, Lynn has reminded me that I'm not very adept at the chat function and all other things. Lynn had sent a chat question for me to give the name of the professor who prepared the brief on bail. So I've put it in the chat function, including the link. It's Dr. Nicole Myers. And Lynn, thank you. I'm just not all that adept with doing, who was it? A former vice president of the United States who couldn't chew gum and walk at the same time. Well, that's me. So anyway, chatting and all of it, but anyone who wants to look at the chat function, the name, title, and link of that brief is there if you're interested in seeing it. So sorry for the interruption. I just wanted to mention those two things.
No, thank you. Well said. Thanks, I appreciate that. All right, the next active item on the agenda is sub item I, proposal for discussion. I'm actually changing the reference because it says seek provincial support. It should be federal, provincial, and territorial support for including criminal records as a ground for discrimination in human rights codes. So I sent everybody as a separate item, an attachment. It's a very brief memo that I prepared on this particular issue. So I've revamped the chart, setting out which jurisdictions address the issue of a criminal record with respect to as a grounds for discrimination. And as I indicated in the brief, there are no jurisdictions that state that a criminal conviction is a protected ground outright without anything attached to that. 5 jurisdictions where there is no protection on the ground, and the remaining jurisdictions provide limited protection. So in BC, PEI, Quebec, and Yukon, there's protection in their codes with respect to someone who has a criminal conviction, but that conviction does not relate to the employment they're seeking. And I've given you a brief excerpt of what is actually in the BC code. In Ontario, the Northwest Territories, Nunavut, and federally, there's limited protection if the individual has a pardon or record suspension with respect to their conviction. All right, and so what I'm proposing is that we move forward with respect to a recommendation. It would go to the Uniform Conference of Canada, pursuant to Howard's earlier suggestion, seeking that all jurisdictions take up the example of British Columbia, for example, and what have you, and basically carve out a criminal conviction as a grounds for discrimination, as long as it's related and limited to the employment application process. But that's just me. So I'm opening the floor for comments or questions in that regard. Anybody? I mean, and I think Howard mentioned this earlier. I mean, the easier route, to pursue would be to expand the Ontario model across the country that simply says that you can't ask somebody about their criminal conviction if they have a pardon or a record suspension, right? That's certainly that would be less contentious than what I'm proposing, but it's as we've seen on the numerous iterations of the bills that Kincaid has put forward with respect to spent conviction regimes, the whole process of obtaining a record suspension, and even though the fee has been reduced, and even though it's automatically available if it relates solely to a pot possession conviction, but beyond that, keeping that as the only ground for discrimination doesn't take away from the onerous process that's in place to actually get a record suspension, right? The rules are different across the country. Ontario and British Columbia have different rules than the rest of the country based on cases dealing with charter rights. So having said that, I just happen to think that if the description is carved out to deal expressly the way it is in British Columbia, that sets out that a person who's been convicted of a criminal or summary conviction offense that is unrelated to the employment or to the intended employment of that person. So as long as the conviction does not affect the job they're applying for in some way, then the conviction should not stand in the way of the employment process itself. That's my view, but again, I'm open to the floor. Becky's nodding.
They're very good students.
We'll take any comments. Any thoughts whatsoever? I mean, do I have agreement that the way the discriminatory ground is contextualized? Do I have an agreement that I proceed with, will be just a little bit more fulsome brief for adoption, then onto the board? Is that the idea, or do we want to back up? Yes, Howard.
Miles, does the protection in BC include voluntary activity? So is it just focused on employment, or also volunteer activities?
I'd have to pull it up. I have it in my background material. I don't recall there being a voluntary exception in that regard. I just saw the provision dealing with employment itself. I can check that, however.
But the reason why I raise it, and Lynn's got her hands up, so I don't want to take too long here, but the last time the PRC talked about this issue, there are some sticking points. I personally favor, as do you, the automatic expiration after a reasonable period of time without further conviction. But the time period, whether or not there has been a pardon or a record suspension, was an issue. The other point of it is as well that most of the systems include a carve out of certain kinds of offenses from the protection, sexual assaults against children. And so the reason why, as an example, and so the reason why I raise this is, although if I understand correctly, under the BC model, you could not discriminate for employment purposes, even where the record was for a sexual offense against a child, provided it didn't relate to the employment, but you could or could not discriminate for the purposes of volunteer activities, such as volunteering with a child related group. I just wonder if we need a little more clarification of some of the sticking points that we've run into in the past. So.
Yeah, without a doubt, I can certainly review the legislation to see, or the code, to see if in fact there is that voluntary aspect to limiting it as a ground of discrimination. I have, that can be easily done.
I just wanted to say, Miles, that what I find most interesting is the split across the country, and that sort of speaks to volumes about we haven't got our act together nationally, and Canada, it has limited protection itself, like from the federal standpoint, and so even though the federal, provincial, and territorial ministers are always talking back and forth about all sorts of stuff, this is still totally split up all over the place, and I find that speaks more to a disjointed approach overall than anything else does. I also, picking up a little bit on what Howard had to say, the one part that does concern me is somebody who does have a record for sexual offenses, especially against minors, and being able to weed that out immediately, and whether it's for volunteer activities or for actual employment, say in a daycare center or something like that. I think we have to be very, very careful in that regard. There's you may go 10 years without offending, and then all of a sudden the urge hits, and we've seen that. So that's the one piece, and I think that was part of the big argument that we discussion that we had regarding some of what Kim Pate's thoughts were put forward. What about the sexual offenders? So that's my point. Thank you.
It's a good point, Peter. But it's kind of a dichotomy, between the Kim Pate's proposals for a spent conviction regime and what this proposal deals with, because we were talking about, and the board was very clear about this, is that when it comes to a spent conviction regime, if the conviction simply wouldn't be spent if it dealt with child molestation of that nature, that it would always be available to be seen, essentially, and wouldn't disappear. And the board was pretty clear about that. But when it comes to human rights kind of thing, and if we put forward that the discrimination, it protects those where the conviction does not deal with the context of their employment or volunteer work, are we then basically saying, all right, it does have that kind of conviction dealing with sexual assault that is immaterial if it doesn't deal with employment or volunteer work. So, you know, it is a dichotomy. Yes, Irving.
Just a question. Do we have any results out of BC? Like, has some evaluation been done to demonstrate how well this legislation actually works in practice?
It's a good question. I haven't done any research, any secondary research beyond the legislative provisions, the primary sources. So I can. It's also primary as well. I can look at case law, and I'll do that for the purposes of preparing a brief.
I'm just curious. Pardon me. I'm just curious because in terms of practice, I could see some issues around the definition of related to employment or not. You know, a potential employer can play with it, right? You can adapt it to your heart's content in some cases. You know, if you think of how things work in the real world.
And that's the stuff of tribunals, right? That's, you know, you apply and you're turned down. You know, your recourse is obviously to the Human Rights Tribunal in whatever jurisdiction you are, and they'll rule. They'll say, you know, either this particular activity is protected or it's not, and that's, you know, and which is much. They tend to be much faster than, you know, going to court. You know, these kind of things, and so they're more expeditious. But you're right. That's, you know, look, I'll check. I'll take a look to see what I come up with respect to case law.
Thank you.
Sure.
Oh, yeah, I have just a general comment. I know from experience, I applied to volunteer with the elderly and also with kids. They're both considered vulnerable groups, so they definitely asked for a criminal record check. And I assume that I have no record at all, but I assume that they probably have a lot of leeway, discretion as to what they do if they find out that you have a record of sexual assault, for example. My sense is they probably would say, sorry, but, you know, because of your record, it pose a potential danger to our clients, which might be kids or to elderly people. And even if they didn't, I think if the people that these volunteers would work with found out that the volunteer had a record of sexual assault, that could really jeopardize the relationship between volunteers and the clients and the organization and the clients. So I think it's important to look at the fact that some of these people are vulnerable and they need protection. I guess that's my comment.
Yeah, you're absolutely right. I mean, I've done a bit of work on this with the John Howard Society. There are very few volunteer groups that don't ask for a vulnerable sector check when you apply for a job. It's just ubiquitous across the board. The difficulty, of course, is that, you know, the majority of employers, no matter what the nature of the job is, apply for criminal record checks these days. You know, it used to be a rather infrequent request. Now it's quite common. So, you know, people with records that have, you know, again, nothing to do with the employment whatsoever, and maybe old records, they may be, you know, something that, you know, again, you know, is obviously out of character for the most part. And that stops their employment opportunities, no matter what the job entails. So you're right, you know, Stefan, there's the vulnerable sector component of it, which makes immense sense and is appropriate for those kind of jobs. But, you know, a sweeping practice, which it has become, of requiring a record check for no matter what the job is troublesome.
I agree.
Yeah. Yes, Howard.
No, so I mean, there's, as you point out aptly, there is a distinction between what you're looking at here, which is provincial territorial human rights codes, abolition of discrimination based on a record in certain contexts, versus the liberalizing at the federal level of the availability of the record suspension or the pardon. And they're different things, but they're certainly some related elements. And I think there may well be a lot of sensitivity points, even at our board, on related to the kind of offense, the kind of activity, how broad it is, what's intended. And I think your brief just would need to provide a little bit more detail. And we talked about the voluntary sector, particularly with respect to vulnerable victims, but also even housing. Does it prevent discrimination from a landlord based on a past conviction for sexual offense against a child, and how does that impact when the landlord is renting out a basement flat and they have young children themselves? So all of these are critical points. I know the board will want sort of a lot of detail on how broad it is and where it goes. So I think the more detail in the brief you prepare would help us have a strong sense of this. Again, part of the problem is that the federal government hasn't taken the lead and followed Professor Pate's approach on providing some national leadership on when a criminal conviction should stop impacting negatively on people's lives. But there's some detailed issues that the board and CCJ has struggled with in the past. And I'm going to just for a second, and I apologize, Becky, I don't want to put you on the spot, but I know, Becky, you have dealt with cases of people who are having trouble obtaining pardons or record suspensions. Do you want to share with us any of your practical experience on this? But you don't feel you have to. It's just I know you've got some.
Yeah, certainly. That's why I'm nodding so eagerly. I love this topic. I've done record suspensions for about a decade now. A lot of the individuals I work with are gentlemen in the trades. And I find just the process, it's been streamlined now, but even the forms are really difficult, very convoluted, very, very expensive for the audience that is applying for the record suspensions. And they do have that aspect, I believe, right on the form that if you were convicted of a child-related offense, you're automatically probably not going to obtain a record suspension. So it'd be very interesting to see whether or not they will actually put a time limit on them and whether or not the certain offenses they will include. It'd be interesting to see.
Thanks, Becky. All right, guys. So thank you for all that input. So I will, certainly take the initiative to prepare a brief. I can't promise it for the next meeting, but I will. I'll look at volunteerism. I'll look at the case law and where it's gone before the various tribunals. Interesting, Howard's mentioning, housing, because then we're not looking at the ground of discrimination relating to the employment context. We're now talking about housing, and there may be other contexts where it may be appropriate to look at it. So again, I'll do a deeper dive into the human rights codes and see what may well be available. And I'll come back. I'll come back with a brief, sooner rather than later, I hope. Brendan's joined us. Thanks, Brendan. Glad you're here. Time is our enemy today, right now. So I'm not going to ask you, Brendan, to do your report. I'll ask you to, basically cover both periods of time, if you wouldn't mind, next meeting. I apologize for not letting you into the meeting. I didn't know you were out there waiting in the ether.
That's all right. No, there's a bit of an email mishap.
Okay, well, and again, we'll certainly make sure that doesn't happen again. Next item, I'm adding it to the agenda. It's StatsCan police reports on Indigenous and racialized identity data. Kyle has sent Irving and I'm not sure who else, a bit of a brief overview of what he's preparing on a report in that regard. So I've indicated to Kyle that he can present it at our next meeting when he's here in attendance. So we'll move that over. Okay, let's move to the bills before Commons and Senate. House of Commons government bills. Bill C9, an act to amend the Judges Act. It had second reading on March the 9th, just a little while ago. This is dealing with discipline matters to some degree for judges going through a process with the Judicial Council. I've given everybody a link to a recent piece of media dealing with Justice Russell Brown, who was at a conference. It was on behalf of Louise Arbour, who is a former Justice of the Supreme Court and a very important human rights advocate. And he got into a bit of a scrap with people in a bar, and it ended up being physical, and he was he allegedly made inappropriate advances to somebody in the crowd or this group. They told him to stop. This is their side of it. He didn't, and he ended up getting punched to the ground. And from what I could tell, he hit somebody back. But having said that, No charges were laid, but this group did lay a complaint against him with the Judicial Council, and so Chief Justice Wagner asked him to step aside until it's resolved. And there you go. And I mentioned this at the board meeting yesterday. This kind of thing doesn't help the reputation of the court, and the court has a very high reputation worldwide, the Canada Supreme Court, and nationally as well. But this kind of thing is a bit of a black eye, no matter how it turns out, because it's just publicity that nobody needs. Anybody have any comments on this particular issue?
Miles, I'm just curious, what you laid out, are those still in the world of allegations, or are there a lot of factual basis for it?
Well, the only factual basis that I could gather from the news report was that the police attending the scene indicated that the complaint about Justice Brown's behavior was merited. There seemed to be grounds that for the basis of the complaint, but having said that, they still didn't pursue any charges. So, but all of that will be part of the record when it is reviewed by whatever justices on the committee decide to review it.
I asked the question because I thought I read something in the paper just a couple of days ago from Justice Brown, which doesn't allude to all that interesting stuff.
Yeah,
it's more like a discussion or something. But anyway, we don't know, right?
It really saddens me to see this kind of thing. For this kind of thing, this is the kind of thing that you carry around for a long time.
Oh yeah.
Yeah, no matter what the outcome is.
Tarnishes reputation no matter what. I agree.
Exactly. Yeah.
If I may, I've just put in the chat a link to a new piece, I think today, from Sean Fine of the Globe and Mail, where there's a little bit more information. So it's in the chat for this thing. Now that Lynn has acquainted me with the chat function, the facts seem to be eking out on this slowly, but it's a little bit of one said one thing, one said another. Brown doesn't appear to have assaulted anyone. He didn't punch anyone. He was punched twice and pushed, but the women in the group have complained that he was touching them inappropriately, or at least in an unwanted way, or kissing them, but in a very mild way. But it's hard to know what the facts are, Irving. And I just, my own view is that until the Judicial Council releases its report on this, we ought to just kind of
lay off.
Watch. There's a lot of gossip about this, and we don't know what happened. I feel bad for Louise Arbour, because it was an event to honor her, and this has sort of overshadowed that. And of course, it's not an offense in Arizona to be a creep, but it may be, grounds for complaint to the Judicial Council. So I'm sorry, I'm just joking. The whole allegation against Justice Brown is that he behaved in a little bit of a creepy fashion after they invited him to join the table. Right. Clearly, public intoxication is always a problem. And it played large in all of this. But have a look at Sean Fine's piece. There was also a piece in the Law Times as well yesterday. But it's, he said, she said, it's gossipy. It's Brown was clearly assaulted physically, whether he provoked it, but the local officials in the states aren't charging. So it's just a question of whether Judicial Council thinks this impacts his behavior on the court. One of the things I think is most interesting is people are worried that this kind of shuts down the SCC. It does not. The SCC is totally able to function with a panel of 8. They'll sit in hearing panels of 7 or 5, sometimes even 3. But there's also a provision in the statute that allows them to call up a judge from the federal court if they need the extra person on their bench. So it's not really impacting seriously the SCC, but it certainly has titillated the minds of the public, and I kind of wish it would all. My own 2 cents worth is I wish people would stop talking about it, and let's wait and see what the Judicial Council reports on it. So,
and that's exactly what we're going to do. So, whenever there's a decision, we'll bring it to the attention of the PRC. But until then, it stays where it is.
I just have to jump in for 1/2 second. I know this is to do with the federal appointments and federal courts, but at the same time, getting in a punch up in the bar is one thing. That being said, when we have a racist judge sitting in Alberta and we can't get that removed, I know there's different appointments and we're almost apple and oranges, but they're still judges. And it's too bad we don't have the act covering all judges across the country. So that's my 2 cents.
Thanks, Peter.
There's a recent case that was brought to my attention that a judge in Alberta had said in the context of a rape trial that to the accused that you know sometimes persistence pays off. In the context of the accused saying, well, he was trying to get a romantic relationship with the woman going, and you know she initially said no, but and it sounded like the judge was saying, well, you just keep persisting in your bad behavior. But anyway, it's all judges need to be held to a higher standard, Peter, and you're absolutely right. It's important to enforce those standards both with provincial and federally appointed people. But I don't know what happens in a resort in Arizona when everyone's drunk, and it's I don't. It's watch a little bit like watching a slow motion train crash or train derailment. But
all right, guys, thank you very much. Let's move on. Next is Bill C-39 made. We have Howard's comments on that. It had royal assent on March the 9th, so very recently. Bill C-40, again, as I mentioned earlier, this is an act to amend the criminal code. It'll amend section 696.1 to basically remove the process of ministerial review for alleged wrongful convictions and or miscarriages of justice, and have them reviewed by an independent body called, well, it's going to be a Miscarriage of Justice Commission, but the formal name will probably be the Canadian Miscarriage of Justice Commission, because there are other ones around. So we've talked about this at length because it was one of the briefs that were prepared earlier. I find it personally very exciting. It's my area of expertise, if I have one, and so the creation of this commission is certainly a step forward. It's as a conviction integrity unit to basically see that those people who believe that they were wrongly convicted have now an independent avenue before a commission to have their case heard, and it certainly is a much more transparent process than going through the ministry. So, having said that, the Bill C-40 had its first reading on February the 16th. It seems to have all-party agreement in moving forward. So hopefully it becomes a reality sooner than later, and we'll keep track of that. Okay. Any questions about this bill? We've covered off the logistics of how it works in previous meetings. Bill C-41 had first reading on March the 9th. This is a bill that basically is a result of the Senate Human Rights Committee report that I presented to the PRC back in January, dealing with the report on Islamophobia, more particularly dealing with the Taliban and Afghanistan. And the report basically said that, as long as it's a crime to provide funds or support in the country, which is connected to the Taliban as a terrorist organization, then funding can't go forward for humanitarian purposes. Particularly from the Red Cross, that was part of the report. So what this bill does is it exempts, for the purposes of a criminal offense, it takes it out of that venue if assistance is being provided for humanitarian, health, education, or human rights purposes. So it very much follows up on the Senate report passed on, I believe it was December 12th. Okay. Any questions? All right, moving on to private members' bills. So we have Bill C-202. Becky gave us her talk on that, and she's preparing a brief, so we'll wait till that comes before us. Bill 233, an act to amend the Code and the Judges Act relating to violence against the intimate partner, had third reading. Bill C-295 had second reading on March the 8th. That deals with neglect of vulnerable adults. And we have two new private member bills in the Commons. Bill C-320 is an act to amend the Corrections and Conditional Release Act, which basically indicates that it intends that information that is disclosed to the victim of an offense regarding eligibility dates and review dates applicable to the offender in respect of temporary absences, releases, or parole must include an explanation of how the dates were determined. That's for the purposes of the victims. And Bill C-321 It amends the code with respect to assault against healthcare professionals and first responders, and indicates that if assaults take place against those particular persons, it's an aggravating offense or aggravating factor in sentencing. In private member, there are no government bills in the Senate, and private member bills, there are no changes from our last meeting. So that covers our bills. All right, any questions, comments, or concerns for the group as a whole? All right, guys, good meeting, a lot of really good discussion. So thank you very much for attending. And I adjourn the meeting now, and we will reconvene on, I believe, April the 11th next month.
Right.
Hey guys,
Thank you, Miles.
Thank you kindly. Take care.
Thank you, guys. Have a good month. Bye-bye.
Be well. Bye-bye.
Thank you for attending, Becky. And Taylor.